Further hearing the appeals Prudential Assurance Company Limited against Commissioners for Matters Revenue and Customs.
Good morning, my lords. I will be dealing with issues 1 and 4. You may find it helpful. I hope you do.
Can I just have a that's all right. Thank you. Yep.
You may find it helpful if I give you a brief route map of
Yes.
how I propose to proceed. I expect to take something between an hour and a half altogether, and then I'll be handing over to my learned friend.
Who's going to take the rest of your time? Quite a lot of it, isn't it?
Well, he's got the nitty-gritty stuff
Yes, I see.
to go through.
Good.
Which is
All right.
I'll be starting with a preliminary point, which is whether there is some second trial for damages waiting in the wings, which is what my learned friend muttered. The answer is no, not so far as this GLO is concerned. And to deal with that, we can do that very briefly by looking at Mr. Justice Henderson's order following his judgment of the 24th of October 2013. You'll see that there is no such case, not here.
Can we have a reference, page reference?
Yes, I'll take you through it.
Good,
This is just a
Right.
route map. I will actually show you the relevant
Right.
document. Then I'll turn to issue 1, and I will ask first deal first with the question whether the basic principle of EU law upon which the Court of Appeal based its decision, i.e. applying the FNR to portfolio dividends, is Act Clare. I'll address that.
Is use of FNR Act Clare? Yes.
Is the use of an FNR?
Of an FNR.
An FNR.
Yes.
So I'm splitting it into 2 bits.
Right.
Second bit would involve considering whether there's any cogent reason why the adoption of the FNR at the Water's Edge Company here and lower down in the FII case undermines the clarity of the position. Because that's the point my learned friend has been hammering on about whether he is entitled to raise the argument at all, but let's assume he is entitled to raise the argument at all. Does that affect the clarity? And the answer to that is no, it doesn't, and I'll explain why.
Well, it's clear enough that it's FNR, but it doesn't have to be clear which FNR.
Yes, and if you want a sneak preview of what I'm going to say...
Sorry, I keep on pushing
no,
you.
why not? It's for the National Court to decide at what level the FNR is to be applied. It's as simple as that, having regard to all the facts of the case. When you're dealing with a group, and that's exactly what ECJ2, in FII ECJ2 was dealing with, the corporate roots, corporate branches was one of the biggest issues in it, then it was quite appropriate for the National Court to decide the FNR should be taken at a lower level, because that particular test claimant group held nearly all of its overseas shares through what's called a mixer company in Holland, which didn't pay tax. It's as simple as that. So it's a matter of the...
Was the mixer company the EU Water's Edge company then?
Yes. I don't know if you're familiar with the concept of mixer companies. Because of the particular rules we had for allowing credit, where there was a larger shareholding, allowing credit, you could have tax being paid in one jurisdiction at 60% and in another jurisdiction at 10%.
Yeah.
And the 60% was larger than our tax rate, and you couldn't get the full amount. So everything went up into a mixer company, and then a dividend came out. And the idea was to blend the dividends, that was a sort of the jargon expression, blend them, so that they bore underlying tax of roughly the same rate as the UK, and then you got the full tax relief. Otherwise, the tax relief was lost. So that was the situation in the FII case. And when, I'm not going to spend a fraction of the time my learned friend did in giving you a tour d'horizon of these cases. When we went to the ECJ first time round, we took a very simplified structure. UK company, overseas company.
So, I mean, the effect in FII ECJ2, therefore, of looking at the ultimate profit-making companies was effectively to avoid the little device which was involved in setting up the mixer company.
It's not avoid, my lord, with great sense. It's to take account of. There's no tax avoidance. You had to.
No, I wasn't saying, I didn't use it in that
Yes,
word. I know
you had to have a mixer company because of the way our legislation was drafted. If you grant permission, not you, but if permission is granted by the Supreme Court in the FII appeals which have been parked for the last 10 years or so, one of the most fascinating questions is whether the change of the UK rules under something called UFT led to a new regime which entitled us to go back before 1993. It's such a fascinating topic. But the way in which relief was given for overseas tax was standard until 2000 or 2001 when it changed. And ECJ2 addressed the complications that our tax credit rules had imposed by requiring mixer companies. That was what ECJ2 question 2 was all about.
Yes.
So ECJ1 was a simple structure because the questions were so difficult. They were totally novel questions. There were so many that the ECJ had to grapple with. We thought we'd present it on a simplified basis. We didn't appreciate that that would then lead to ECJ2 having to look at roots and branches. We thought that that would be pretty obvious.
One thing's quite clear, that neither Mr. Hewitt nor you will ever be able to retire.
Don't let my wife hear that, please, my lord. In fact, it was only this morning when she wondered whether it was... Anyway, I won't go into that. There we are.
We're still on point. Which point are we on?
Yes,
we were just...
We have the road map.
Issue 1, little 2 we've had.
Exactly. Issue 1, little 2, does it make any difference to the clarity? Is the clarity
yes.
reduced by the fact that in this particular case, the judge opted for the top? And I'll explain to you, in fact, the rationale of the ECJ in ECJ2, FII ECJ2, was to take the top company. That was the basic rationale. And I'll show you the paragraph. It's paragraph 61.
Right, next,
anyway,
next
okay.
issue.
So there we are. That's it, as far as issue 1 is concerned.
Right, so issue 4.
Issue 4 doesn't arise if you're with us on issue 1, but let me assume that I'm going to address you in full on
And
that.
it doesn't arise if we decide to refer issue 1, does it?
No. If you decide issue 1 in our favour,
Yes.
there's
Issue
no
4
problem.
doesn't
There's
rise.
no problem.
But equally, if we decide, as we're being asked to do, to refer that back to Europe, then we defer issue 4 as well, do we?
That will be not merely beyond my retirement, it may be beyond my existence. One would hope that we would get some judicial guidance.
I mean, in other words, you would like us to express a view on issue 4
if you're against us. If you're against us on issue 1.
Yes.
Even if
And
we
there is no
retired,
reference.
Sorry, if we referred.
If you refer, yes.
On the hypothesis that we're against you in issue 1 and there is no reference, your position on issue 4 is?
I mean, as
becomes
I
rather
understand it, Mr. Hewitt's not asking us to decide in his favour on issue 1. He's saying we should refer.
I know.
So the issue on our addressing doesn't arise.
Unless you decide
And
your own volition that the point is
Exactly.
so clear in favour of HMRC that there's no need to refer. Yes. Look, I will address you on issue 4.
It depends what sort of judgment we give. I suppose if we refer, there may be some points we can decide. Anyway, carry on.
Yeah. So issue 4, you'll need to consider whether the principle of effectiveness requires the legislation either to be partially disapplied and treating the dividends as franked investment income, or requires some practical surrogate for the actual tax. I mean,
this is the argument. If you lost on issue 1 as a result of an ECJ decision, the appellants say that there's no fallback open to you.
Let's say there's no fallback. We would have to prove. They say we would have to prove,
Which you failed to do, they say.
which we failed to do, and you could say hard cheese or tough cookies, and I think the German is hecht gehabt. Das ist das Leben? Das ist das Leben. That's,
Say it again.
that's life. Yeah, they have no sense of humour.
Leben.
Yes.
Das ist das Leben.
Das ist das Leben. Das ist das Leben.
Yes.
There we are. That's wrong, and I'll explain why. If you actually read Haribo, and I have to take some of the blame for this, if you read Haribo, you'll realise that the only question that mattered is question 3, not question 2. I'll explain why. It's a bit cryptic at the moment. The learned judge went wrong because he thought question 4, which my learned friend took you to yesterday, dealt with judicial remedy for a lack of a credit. Question 4 does not deal with that at all. The only question that is relevant is question 3 in Haribo, and in Haribo, question 3 was answered by saying that the rules are precluded.
It's answered by saying?
The rules are precluded. Thus might be...
Will we be looking at Harry?
Oh, yes, we will indeed be
I mean,
looking at...
Right.
I'm quite keen to keep them for my personal self, to keep the roadmap separate from the discussion.
Yes, okay, well, we will be looking at Haribo.
So that's issue 4,
That's it.
right?
Then I will introduce my learned friend as his last address as a junior. He takes silk next Monday.
Oh.
And had he had taken silk this week, we would have come robed, so he could be dressed up for the occasion, but there we are. So, may I then move on? The preliminary point, is there a second trial for damages waiting in the wings? The answer, not so far as this GLO is concerned. We need to look at the order of Mr. Justice Henderson of the 28th of January 2014. That is in the core bundle, Appendix 1, at tab 6. I'll spend much time on it.
MS
Big
number, MS.
3572.
the MS number, we start with 3572. Can I make a little advocate's point at 3572? See, this is Miss Justice Henderson's order.
Parties having agreed to this. Is that right?
See the second paragraph?
Yes.
Upon the resumption by order of 20th December 2012 of the trial previously heard on the 24th of January 2005, 18th and 19th November 2009, 20th and 21st May 2010. Now, of course, I wouldn't dream of trying to influence your lordships about not making another reference, but this is ridiculous. I mean, this trial started in 2000, the actual trial started in 2005. We had a hearing. I mean, this is my 4th brief fee. You know, will I be here for the 5th? So this is, you know, it's ridiculous. Anyway, if we turn over, you see the next page. And upon hearing counsel for the claimants and the defendants at the resumed trial of the claimants' claims on 15th, 19th July, on all issues, save only for the quantification of the amount of damages, we were claiming damages, and compensation or restitution. While we weren't claiming damages as such, we were making claims which the judge held to be damages claims, and therefore, as there was not sufficiently serious breach, we weren't alleging there were, we couldn't actually claim for them. On all issues, save only for the quantification of the amount of damages and compensation or restitution. So the trial was of all the issues. And then if you go over the page to the declaration, it's hereby declared that the GLO issues not otherwise agreed as set out above are answered as follows. If you turn to MS 3576, you'll see that this was our claim, which the judge considered sounded only in damages. The claimant cannot claim, this is para 5, the claimant cannot claim an additional amount in respect of tax credits comprised in surplus UKFII under section 2421C, to the extent that the setting aside or reduction of the D5 charge, you don't need to know what that was all about. This was a technical life assurance issue. We were making a claim for compensation in respect to that. He held that that is not a restitutionary claim. And then 3578, we have the order at the bottom of the page. It's hereby ordered that. Turn over to 3580, paragraph 6, the following claims fail.
350, paragraph 6. Yes.
3580,
Yeah.
two claims failed. The claim for an additional amount in respect to tax credits comprised in surplus, that's the 2421C point. And then the claim in respect to 1990 accounting period only for recovery of tax credits foregone. They failed. End of trial. There is no damages trial waiting in the wings. I don't know where my learned friend got it from, maybe from the original pleadings, but we were pleading Human Rights Act and heaven knows what else, Bill of Rights, you name it. We were claiming everything. But that fell by the wayside, and as the Court of Appeal below pointed out, the pleadings really weren't sharpened as they ought to have been done by either side. So can I move now to issue 1? Is the basic principle of EU law upon which the Court of Appeal based its decision act clear? And the answer is yes. Can we start by looking at the reasoned order in this case? Again, it's in the bundle you have open in Appendix 1 at tab 10.
Yes.
And if we start at paragraph 34, which is at MS 3723. It may be helpful, I don't know if I took you to this, but just to actually read it once again and consider what does it say.
Paragraph, sorry.
34, my lord, 34.
34.
The question is referred for a preliminary ruling. Under the first paragraph of Article 104.3 of the Rules of Procedure, where a question referred to the court for a preliminary ruling is identical to a question on which the court has already ruled, and then it's the next clause that matters, or where the answer to such a question may be clearly deduced from existing case law. Clearly deduced from existing case law. The court may, after hearing the Advocate General, at any time give its decision by reasoned order. So, they clearly deduced the conclusion from the existing case law being FII ECJ1. If the matter were referred back to the court now, with great respect, you'd get the same reasoned order. This time, they would be clearly deducing the answer from the existing case law, which is FII ECJ2. It really is as straightforward as that. That's what a reasoned order is. It's simply applying the existing case law as it stood at the time of the reference. While we have this open, it's to save time going backwards and forwards.
So the position is actually, this is Mr. Justice Park's reference originally made before FII 1, but maintained after
Exactly.
FII 1 in response to a letter from the Court of Justice.
Exactly.
So they're really saying, just read our decision.
Well, they wrote, said, do you want an answer?
Yeah.
You've just had it.
Yeah.
In FII 1.
Right?
Yes, I mean, the essence of your argument is if you read FII 2, then you say it's clear that it applies both to non-portfolio and portfolio dividends, ergo act clear.
Yes.
Yes.
It really is as straightforward as that. I'll elaborate it slightly. It won't take very long, but I'll wait till I elaborate it rather than giving a preview of an elaboration.
But so you say this reasoned order has been completely superseded?
Yes, it's what the Court of Appeal said. I think they said if the foundations move, the superstructure moves with it.
Yes.
So to say, oh, there's an inconsistency between the reasoned order and ECJ2, well, of course there's an inconsistency. ECJ2 is the contemporary jurisprudence. But while we have this open, if we turn to MS 3727, paragraphs 58 and 59, I read it now, just say going back to it later. 58, on the other hand, since it's clear from the decision making the reference that companies with a less than 10% shareholding in the company making the distribution were not entitled to relief in respect to corporation tax paid by that company in the member state in which it was resident, those companies were, contrary to Article 56, subject to less favourable treatment. I mean, this is always the approach. You just simply have to take the UK domestic system and compare that with the system that applies when you have an overseas shareholder.
Yes.
And then look at what the UK government says. Even in this reference, they said it in FII, but they said it here again. According to the UK government, it's legitimate and proportionate to restrict the availability of the corporation tax relief granted to resident companies to the amount of any withholding tax levied on the dividend. So you restrict it only to withholding tax. Practical obstacles would preclude a company with a less than 10% shareholding in the company making the distribution from benefiting from a tax credit corresponding to the tax actually paid by the latter. Unlike a tax credit given in respect of withholding tax, such a tax credit could be granted only after lengthy and complex checks have been carried out. It's therefore legitimate to set a threshold by reference to the size of the relevant shareholding. So that's the reason the UK gave for not giving any credit. It's just too hard.
Just explain to me what the difference between a tax on a dividend received and a withholding tax levied.
Yeah. A withholding tax is a tax that is applied by the other state, the state of the dividend-paying company,
Right.
and requires it to be deducted at source. So a dividend of 100 is declared, German tax of 30 is deducted from it, and the recipient gets 70. It's dead easy to know how much has been deducted because you get a slip of paper saying your dividend was 100, from which tax of 30 has been.
I see. So, whereas other tax is just tax levied without diminishing the amount paid.
Exactly.
Yes.
Exactly.
Yeah.
And it's very difficult in the case of portfolio shareholdings to actually find out what commercial tax was paid, if I can put it that way, what corporation tax was paid. It's very difficult.
Which is the very reason the revenue was giving for not doing it.
Which was the reason the revenue were giving the ECJ, not the reason they're giving you.
No.
No. The reason they're giving you now is quite different.
Yes, because they say Haribo says, und so ist das Leben.
Oh, no. It's worse than that. It's worse than that. What they say is, in their, and I'll take you to it, in their written case, they say the reason why you don't get a credit is twofold. First, a portfolio shareholder isn't interested in the underlying tax. Do you remember that? That's what they say. They're not interested in it. And secondly, the problem that affects groups, which is that you have a large slug of underlying tax, doesn't actually apply to portfolio shares. As if there's a difference between a 9.9% shareholding and a 10% shareholding. I'll come to that, because this is really important. It is critically important to answer the question whether there is any principled reason at all why portfolio dividends should be treated differently from larger shareholdings. Is there any reason at all? The answer to that is no, there cannot be any reason at all. For the reason given by my Lord Hodge yesterday, or not given, very succinctly summarised. You're looking at the UK domestic situation where you have a company that owns shares in another UK company. The problem that emerged and was dealt with in FII ECJ2 was that if the lower company paid tax at an effective rate lower than the nominal rate, in the domestic system, the benefit of that lower tax rate was preserved because the dividend was exempt when it reached the hands of the shareholder. But if it was a foreign company with exactly the same tax benefits, exactly the same benefits, once the dividend went up to the UK holder, it was fully taxed at 30%. And that was the same whether it was 100%, 90%, 80%, and to save time, I'll go straight down to 10.1% or 9.9% of the shares. The problem was exactly the same. So there can't possibly be any principal reason, apart from practicality, why there should be any different rule at all.
But historically, I mean, do we know whether the reason given in paragraph 59 is the reason why portfolio companies were treated differently? Or is,
One assumes...
one assumes if they were saying that, that's why, why it was done.
Well, one assumes that's what an order for reference is.
Yeah.
That was the UK's position. They said that...
No, I just wondered, because you have a lot of experience of this, whether we know...
Well, I don't. It's a perfectly sensible, understandable reason. But how do you actually check?
Yeah.
If you're a portfolio shareholder, how do you check? If you're the revenue. So that is the reason, but that reason was dismissed in ECJ 1 as an irrelevant reason. Simple as that. It's not an overriding principle that justifies, it's not a justification for the discrimination. That's what they decided. Now, I don't know whether I ought to rub my learned friend's nose in it or not by taking you to their stated case. I think I shall. I've got the time to do it. If we look at what they say, it's in the core bundle under the tab headed case for the appellant. So it's before...
Right, yes, page.
Now, it should be MS 3373. If I've got
I mean, is your point here that this is just disingenuous, or that it's a bad point, or both?
I'm not sure we're making either points. I don't actually see that this forensic point has anything to do with the question what the ECJ decided.
Well, that's what I'm wondering too.
Well, your lordship is, of course, right.
Good.
So we'll save a bit of time. So I
think we've got so many things to worry about in this case.
yes, but so no, I'm not inviting a criticism by learned friend by the bench. Suffice it to say that the reason they put forward at paragraphs 91, 92 and 95 are not
Yeah. I mean,
sustainable.
what is of interest is the reason the court rejected this as a proper consideration. It knocks into the next stage, as whether one's thinking about the FNR or the effective rate in the method that they then apply.
Yeah.
And das ist das Lebenspoint.
That's right, and it is important, and I will come to it. But you'll see, das ist nicht das Leben,
I see.
as it happens. So there we are. I won't deal with that. Are there any other indications that the case law of ECJ2 or FII ECJ2 ought to be applied to portfolio dividends? The answer, I would say, is yes. There's frequent cross-referencing, as you would have seen in the Haribo case, which was a portfolio dividends case to FII ECJ2. Reference to it all.
Frequent
cross-referencing in Haribo. To in ECJ2 to Haribo.
I was going to say
yes. So it's the other way around. ECJ2 came after Haribo. Frequent cross-referencing, never a suggestion that there might be any different.
Well, and it's the same
same
rapporteur,
absolutely,
who
absolutely
knows his onions.
Absolutely. So can I move on to the second part? I've made my submissions on the first part, that it is act clear that an FNR is to be applied. Is the clarity reduced in any way by the fact that in this case, the trial judge, upheld by the Court of Appeal, took it to be the FNR at the Overseas Water's Edge Company, whereas it turns out that on the second or third, I can't remember which hearing it was, in FII, the same judge considered that it was appropriate to take the FNR at a lower level? And the answer is no, it makes no difference at all. And I would ask you to address it in this way. What is the basic rationale, what is the basic analysis that was adopted by the ECJ in FII ECJ 2? What's their basic analysis? And the answer to that, and I'll take you to the passages soon, the answer is that granting exemption to domestic dividends, which is what we did in the UK, is similar to granting credit at the nominal rate in the hands of the company paying the dividends. That was the rationale. That was the actual expression.
But is that actually correct? Surely the value of the exemption is equal to the amount of the tax that would otherwise have been payable. And without the exemption, it would have been paid at the effective rate.
I'm sure your lordship's right, because your lordship usually is, but I'm afraid I'm just.
Well,
not
I wouldn't accept it for that reason. I mean,
Yes, I've been struggling with this.
I think you are right to say that that is the assumption
Yes.
that the CJEU made.
Oh, yes. Is it a right assumption?
But is it correct?
Oh. It's rough and ready.
Well, it's not just rough and ready, it's wrong.
Well, that's another way of saying rough and ready.
All right.
But
So long as we agree that that's the vocabulary we're using.
yes.
But, I mean, it's an assumption of fact that seems to be pretty critical and which doesn't actually seem to have been considered on its merits. It was simply assumed.
Well, it is, at a simplistic level, it's easy to see that if I am a shareholder receiving a dividend from a company in which I have shares and I don't pay tax on it, it's as if I'm giving credit for the full amount of tax that has been notionally paid.
Well, at the notional rate.
At a notional
rate,
yes.
even if that dividend in fact comes from a company which pays tax at a lower rate,
Exactly.
emanates from.
Yes.
And it's just applying that. I mean, one can say it's unrealistic because, I mean, I don't suppose anyone pays tax at the, if you look at the overall picture at the...
But in some countries they do. In some countries
rate,
they do.
You do
They have
all the way from naught income up to 100,000.
Some sort of flat rate, low flat rate taxes.
I see.
Yes.
Yes, but I mean, in this country we have all sorts of...
Oh, well, we had in the days when my Lord Carnwath was sort of familiar with our tax code, we had the most ridiculous...
Very long time ago.
Yeah, I know. Well, but, you know, we ought to be able to remember that far back. It's yesterday we can't remember. But when we go that far back, we had very high tax rates and enormous allowances, capital allowances of 100% and things like that. Right. We had a very extreme case. Other countries had flat tax. And
So they're thinking in those terms, is the,
yes.
is the
Well, I mean, I want to, this is, I found the most difficult thing to get my head around is the logic of taking nominal rates one side in the circumstances where no one actually pays nominal rates either side.
Well, in Europe, they do. There are some jurisdictions with very flat taxes.
But this isn't one of them. This is so that, as applied to the United Kingdom tax system, it's a source of legitimate concern that a rather large superstructure has been erected on a somewhat inadequate factual base.
Yes, and we had this discussion where we had a more leisurely time in the Court of Appeal. This discussion was conducted as to whether it was logical, and I think we all agree it's not the best thing. But the reality is this: if you go back to ECJ 1 and you read the late Advocate General Helgood's opinion, he thought that there ought to be exemption, if I remember rightly. He thought that that was the only logical way of doing it. We should parallel the systems. The Court of Justice disagreed. It was the full court, and Judge Lennox has stuck to his guns. If you read
Why wouldn't an exemption be possible or work?
Because they say, because the objection to an exemption
means you can't charge more.
You can't, exactly.
Than the foreign rate.
Yeah.
non-poor
So he
rate.
was stuck.
Yeah.
He was stuck with this previous decision.
I mean, your answer a moment ago to Lord Carnworth, namely that on the continent people are familiar with paying the notional flat rate, is actually contradicted by the reasoning in FII too, isn't it? Because the whole basis for taking the notional rate is that the actual rate, effective rate on the continent may be lower. So, I mean, where are we? It's not.
You can't square the circle, but that's the ECJ, and that's the ruling that has to apply.
I mean, the more I sort of try to get my head around this case, the more that the consequence of the ECJ's reasoning is we're comparing apples and pears.
Yes.
And we're trying to sort of do an impossible task. Yeah. And your answer seems to be, well, the Court of Appeal did their best, and we're unlikely to do any better, and we're unlikely to get anything better if we refer it to the ECJ. I mean, is that what you're saying?
Yes, the ECJ would just refer it back and say it's to the National Court. We've laid down the principle that you have to apply the FNR to the National Court to decide how to do it.
The ECJ have lighted upon a principle applicable generally, but in particular in this case to the UK, which is based on a failure to take into account a significant factual matter. It may well be that they ought to be invited to consider what, if any, impact that factual mistake has on their reasoning.
One might think that the prospects of the ECJ saying in paragraph 10, 50 or 100, we have misunderstood the position and
that's exactly what they did say in FII too.
Yes. Well, having said it once, are they going to say it again?
Well, I mean, they can perfectly properly blame the Brits for failing to set the position out properly.
Well, the position was set out properly, and indeed, if I can get round to Haribo, when I get round to Haribo, you'll see that the same point was actually taken by Advocate General Cocotte. She said there may be situations, this is before ECJ2, there may be situations where if you apply ECJ1, you find that reliefs aren't being carried up. But, she said, I assume factually that isn't the case here. That's
when you say that
case.
reliefs aren't being carried up, but if you apply ECJ, well, it might be interesting to look at that because she's
clever lady.
But the rationale of using FNR, as I understand it in ECJ2, is that exemption has the effect of giving the recipient company the benefit of an exemption from the tax effectively paid at the effective rate, but also the benefit of the exemptions which got the tax from the nominal rate to the effective rate. And what they were saying was, if exemption does that, then the imputation method must have a similar methodology, which means you have to go to the FNR. That's the essential reasoning.
That's exactly right, my lord, and I'm grateful for your lordship's expressing it again. So succinct. That is their reasoning. I would submit it is not for this court, however esteemed, it's not for this court to refer something back to the ECJ to say we don't actually understand your basic premise in ECJ2. The matter is act clear so far as the interpretation of the treaty is concerned.
It's just that we cannot detect how this principle is supposed to apply in a case where the factual assumption which the ECJ made doesn't apply, viz. Our tax system.
But well, let's assume we're in FII. They've given the decision, and they've had all the facts stated to them. They've laid down the principle. It wouldn't be the first time that the principle laid down by the ECJ is open to some question. But it's not for this court, with great respect, to go back to the ECJ and say it is act clear that the learning in ECJ2, FII ECJ2 applies, but we don't actually understand why you came to that conclusion. That's not my learned friend's argument, is not that ECJ2, FII ECJ2, is wrongly decided. His argument is that it doesn't apply to this case because it's portfolio dividends or because we got the FNR at the wrong level. That's the case we're grappling with.
And he's also saying that, in principle, FNR is the wrong choice.
Judge Lennox is now the president of the ECJ, so whether he's going to really take seriously the proposition that the analysis which they laid down and which followed to a degree, quite a considerable degree, the submissions of the Commission, who considered that the only way you can really equate an exemption system with an imputation system was by treating the imputation as being at the nominal rate. That was the Commission's approach.
Do we have that? I mean, don't go to it, but a reference would be helpful.
We'll give you a reference. I think we have it actually in there. Yes. Yes.
Yes.
Slightly diverted, can I go to FII ECJ 2 and look at paragraph 61? This is in Authorities 8 at 2809, 9 tab 73. This is the rationale. Para 61. At 2809. The tax exemption to which a resident company receiving nationally sourced dividends is entitled is granted irrespective of the effective level of taxation to which the profits out of which the dividends have been paid were subject. That exemption, insofar as it is intended to avoid economic double taxation of distributed profits, is thus based on the assumption that those profits were taxed at the nominal rate of tax in the hands of the company paying dividends. That is the basic assumption.
Yes, but I mean, that's the assumption.
Yes.
Which may be incorrect.
It may be
incorrect.
It may be incorrect, it may be illogical, but that's the assumption which the court has adopted. It's the Grand Chamber.
Yes, but it's a factual assumption. It's not a proposition of law. It's a question of fact.
No, with respect, my lord, no. It's a conceptual matter. It's not factual, it's conceptual.
No. If you assume that profits are taxed at the nominal rate of tax, that is an assumption about how profits are actually taxed, which may be factually correct or factually incorrect.
No.
And it turns out...
Well, it leads to a proposition of law. I mean, if it were a factual assumption, there wouldn't be any question of a reference.
It leads to a proposition of law, but the question then is, what do you do if the proposition of law is sought to be applied to a state of facts where the assumption is different?
But the proposition of law arose from precisely the state of facts of the United Kingdom presented to them, and it's all emerged from the emphasis we put on the fact in oral proceedings in ECJ 1 that the exemption method gives far more relief than the credit method, because in the UK we have very high allowances and they're not passed through. The allowances are cancelled out if the allowances are enjoyed by overseas companies, whereas they are carried through if they're enjoyed by UK companies.
So whether or not the system was devised on a set assumption, your point is the exemption has that effect.
Well, that's what they go on, isn't it? It thus resembles grant of a tax credit calculated by reference to the nominal rate of tax. It resembles it.
Yes, I mean, the recipient of the dividend in the UK gets the bonus that it's increased by the amount of the additional reliefs which the paying company has been able to make. You said that General Cocotte had said something interesting about the way the
Yes, I
English
can
tax
take-
system worked, the British tax system worked. Is that right, or did...
It's not about the British tax system. She was talking about the Austrian
The Austrian one, all right.
tax. Yes,
Can you refer us to that?
Would you like me to take you to?
Well, I think it might be, in the light of the discussion, helpful to have anything which shows that the court is well aware of this sort of point.
So this,
Maybe it's in Advocate General Jeskerson's opinion as well, I don't
so
know.
this will be in volume 7 of the authorities. It's behind tab 62. I think the place we'll find it is para 57. Starts at 57 on MS 2409, and then we'll need to go a little bit further to conclusion. So if we look at 57, if I got this right, oh no, sorry, that's the wrong reference. Let me just find the right reference to this. Yes, I think it is 38.
38.
33 is the introduction to it, is it?
Oh, 30, we'll just perhaps start at
It's
37.
30, we start at 33.
33.
If a member state decides to exempt national dividends from corporation tax, not because it wishes in general to refrain from taxing distributed corporate profits, but because it wishes to prevent the economic double taxation of such profits in that way, it's assumed that the desired level of taxation is already guaranteed through the levying of corporation tax on the company making the distribution. This internal link may be partially or entirely absent in a specific case where the corporation making the distribution benefits from specific tax advantages. In my opinion, however, the examination to be conducted must be based not on an analysis of specific cases, but on an overview of the system. And then in 35, MS 2404, in test claimants in the FII group litigation, the link between the exemption applicable to national dividends and taxation at the level of the company making the distribution was addressed by the court only tangentially. The claimants in those main proceedings had argued that exemption of national dividends applied irrespective of whether and to what extent tax was paid by the company making the distribution. The court therefore asked the referring court to determine whether the tax rates were indeed the same for the company making the distribution and the recipient company, and whether different levels of taxation occurred only in certain cases, by reason of a change to the tax base as a result of certain exceptional reliefs. I conclude from this that the court did not wish its findings on the equivalence of the exemption system and the imputation method not to apply any longer as soon as it was possible in individual cases, I think that's like exceptional cases, that national dividends were exempt even though the underlying profits had not previously been subject to the full corporation tax charge. In the present case, the referring tribunal points out that the effective tax burden on national dividends in Austria may be lower than the nominal rate of tax, not just in individual cases as a result of the various forms of relief laid down in the corporation tax law. For example, it mentioned the possibility of loss being carried forward in group taxation. In my opinion, however, these generally common ways to reduce the tax burden by being able to include past losses in the tax base and to tax a corporate group's profits and losses on a consolidated basis can't cancel out the close link between exemption and taxation which underlies an exemption system. The same applies to personal or subject-based exemptions from corporation tax granted by way of exception. And then it's the next paragraph, next passage. Only if an overview of the system shows that the link between exemption and advance charges to tax exists merely ostensibly or is even manifestly absent, would it have to be found that in reality the system doesn't serve to eliminate economic double taxation. The referring tribunal must therefore examine whether on an analysis of the Austrian corporation tax system as a whole, there is a genuine link between the exemption of national dividends from corporation tax and the taxation situation at the level of the company making the distribution. If not, it would be a priori arbitrary and therefore unlawful to refuse, unlike in the case of national dividends, an unconditional exemption for EU EEA dividends. So she's saying that if it turned out that you really do have a big disparity between the effective rate of tax and the nominal rate of tax, then an unconditional exemption should be granted, because that would be the true parallel. And then if I remember correctly, I think she restates it to para 70. Let me just check. I'm not sure. No, I don't think so. I think that's the passage. Yeah. So she's raising exactly the same issue. This was the issue that was alighted on also by Advocate General, late Advocate General Hood in ECJ 1, because we had emphasised, this is the thing you see I use my hands a lot and did in the ECJ. I mean, in the 20 minutes allotted, a lot of it was given to hand-waving about, you're not passing out the benefit of these reliefs. We need full exemption. We don't need a credit system. We want full exemption. And therefore, the only way of getting full exemption would actually be, as a matter of domestic law, to disapply the tax on the dividend. That's
so this was your argument?
Yes.
Which didn't succeed?
It didn't succeed.
No.
It was found attractive by the Advocate General. And
in FII?
In FII itself. In FII
one.
Itself,
one,
yes.
yes. And instead you got some reference to actually paid, and then later in FII 2 you say you got the halfway house, which...
yeah, because what happened in FII was, we don't know how, it must be, that there was this footnote written, footnote 64, I forget what it was, footnote written by the United Kingdom, which said that the rates differ only in exceptional circumstances. But they were talking about nominal rates for small companies. But that seems to have been read by the court as being only in exceptional circumstances where there's a difference between the nominal rate and the effective rate. And that's why the reference went back to the ECJ saying, no, it's not exceptional cases, it's universal. So the matter was clearly before the court, not merely in FII ECJ 2, also in Harry, because it was addressed by there, and that is the conclusion that has been reached by in FII ECJ 2. So is it Act Clare? Yes, it's Act Clare. Is it Act Right? Maybe not. But
the irony is they might have, had they known the true position at the first stage, they might have been more attracted by the simple exemptions.
Absolutely. Had they got it right first time, they would have probably followed the Advocate General and said full exemption, which is now what we have. We've had it since 2008, 2009, I don't know. That's what's happened. We now have full exemption because it simply doesn't work properly. So to go back to the ECJ and say, by the way, our system 11 years ago didn't grant any credit at all, but had it granted a credit, would your ruling still be that credit should be given at the nominal rate? I mean, I appreciate that there's great intellectual interest in historical matters, but I mean, this really is.
But it's a bit more than that, Mr. Aronson. Very, very large sums of money turn on this.
In this particular case, no, my lord, with great respect.
Well,
large sums of money, but these are...
In this particular case, no, but looking at the issue generally as it affects corporations in the UK, large sums turn on the answer.
But my lord, I'm not going to spend time arguing with your lordship. This litigation started in 2003. FII started earlier than 2003, same time. We're now 2018. We've been to the ECJ 3 times in FII, once here. Are we going to go back a 4th time because there are large sums of money? They're not really large sums of money, they're never being paid. Because of all these cases going on, we're never actually, well, they had made some advance payment, as it happens. Probably, I
Sorry, what did you say? You dropped your...
This is just, I was spluttering, my lord. This case has got to have some finality. And it may, just to say to the ECJ, look, I'm sorry, you still haven't really come up with a cogent answer. What do you want them to do? Say there should be full exemption. Lovely. Thank you very much. You know,
Really, in a nutshell, you're saying they're well aware of Lord Sumption's point and they've decided to disregard it.
they've just, exactly, they've not necessarily disregarded it, they've fudged it. That's the way they've done it.
Did they...
It's a clear fudge, my lord, if I may put it that, act clear.
What were the words they used in FII 2 to change direction? It might just be interesting to look at that.
But they certainly weren't words of contrition.
Where do we have it? 8. Where are we? Well, I was at 61, if I remember rightly.
Where do they refer to the different appreciation of the national system? Do they?
Is it 40? I'm told it's 41. Let's have a, let's see.
Paragraph 41 where?
41, it should be at MS 2807.
Yes, in fact, they rather... Yeah.
It's 48 is where they grasp the point at the foot of 2807. Unlike the exemption method, the imputation method therefore doesn't enable the benefit of corporation tax, which was granted at an earlier stage of the company paying the dividends, to be passed on to the corporate shareholder.
It's really question 49. They then interpret paragraph 56 of their earlier judgment in a way.
And then 52, this is read by my learned friend, it follows that application of the imputation method to foreign source dividends as prescribed by the legislation issue of the MEMCs doesn't ensure a tax treatment equivalent to that resulting from application of the exemption method to nationally sourced dividends. And that's where you get down to the discussion in 61, that it's based, that exemption, as far as it's intended to avoid economic double taxation, is thus based on an assumption that those profits, or a conception that those profits were taxed at a nominal rate of tax in the hands of the company paying dividends. It thus resembles grant of a tax credit calculated in reference to that nominal rate of tax. And then for the purpose of ensuring the cohesion of the tax system, national rules which took account in particular also under the imputation method of the nominal rate of tax to which the profits underlying the dividends paid have been subject would be appropriate for preventing the economic double taxation. And then, interesting, I'm talking, because in my roadmap I was still at the point, does it make any difference that the learned judge and the Court of Appeal have opted for the water's edge?
Yes.
The water's edge FNR and 63. Why is it? It is to be observed in this connection. One can ask the question rhetorically, why should it be observed in this connection? Because they thought it was relevant. Observed in this connection that in Haribo, at para 99, the court, after pointing out that member states are in principle allowed to prevent the imposition of a series of charges, tax and dividends received by the resident company by applying the exemption method of nationally sourced dividends and the imputation method to foreign sourced dividends, noted that the national rules in question took account for the purpose of calculating the amount of the tax credit under the imputation method of the nominal rate of tax applicable in the state where the company paying dividends was established. So they took account of the FNR at the water's edge company. It's to be observed in this connection. Now that's a steer, if I may put it that way, and your lordships were very happy, some of you, to take steers in Littlewoods from what they were saying about there's an awful lot of interest has already been paid. That's a steer that there's nothing wrong with taking the FNR at the water's edge company. That's what was done in Haribo. And it makes sense in a portfolio context to do that. We're dealing with, you take companies like Volkswagen or Krupp or something like that. They're industrial companies, and insurance companies have shares in those companies. We don't know whether their profits are earned. You know, obviously profits are earned in Germany, and they're probably earned down below. Why don't you take the top company? What's wrong? What are you going to do? Investigate and look at every single factory and its profitability and all the rest of it, and whether it's taxed in Czechoslovakia and so on and so forth? Why? We're talking about portfolio investments in major companies. What's wrong with taking the FNR at the water's edge? So, coming back to my analysis, what matters is whether taking the FNR at the water's edge, differing in this respect from the FNR lower down in FII, where the BAT company had its profits taxed much lower down, does that reduce the clarity of the guidance given by the ECJ? No, it doesn't. It's exactly what the ECJ said at Para 61 and exactly what they are steering us towards in 63. And I make the point that it's for the, I made it and I'm going to say it again, it's for the national court to determine, granted that you have to take the FNR at some level, it's for the national court to determine what is the appropriate level. The national court has made that decision.
This issue as to which country or which company is paying the dividends, whether it's the water's edge or the company lower down or higher up, whichever way around you put it, is one which you say is actually not open, and isn't it? It might be just helpful to clarify the formal position, in my mind, at any rate. Somewhere there was an application to raise this issue in front of the Court of Appeal, and somewhere they refused it, didn't they?
They refused it. And
Well, let's look at that.
The reason they refused it was that when the case came back for the final trial before Mr. Justice Henderson, the one I took you to the order from, when the case came back at that stage, the argument was centred on whether the FNR was applicable, an FNR was applicable at all. That's what the argument was. There was no dispute that if it was applicable, it was to be at the water's edge company. That's how the case was conducted. It was after ECJ2. So HMRC had every opportunity, if they wanted to raise the point that you shouldn't be looking at FNR at all, or you should be looking at a different level. They could have said so at that time. The case was conducted, evidence was put forward, the evidence was accepted. The whole case was conducted on that basis. The trial was conducted on that basis. I think, was it a 2-week trial? I forget.
Where do we find that reference, Mr. Adamson, to the Court of Appeal rejecting that particular?
Can I take you to that when I look at the Court of Appeal? It is. I was going to at the end take you through it, but I can do it now. Okay, the second I've got my own. So that would be in the core bundle at tab 1.
Tab 2.
In the appendix. Page, what's that? 3500. Sorry, I'm not sure we're across, but you're asking where the...
No, it's just that if your case is at this point is not open because leave was refused by the Court of Appeal to appeal to them on the point, I would certainly hope...
Yes, it's the order is at MS 3499 behind tab 1. 3500.
Sorry, 3499.
It begins at 3499. That is the order. It's at 3500. You see, it is ordered that 1, permission to appeal is refused in respect of issues, and then dot 4, appropriate nominal rate.
Well, okay, where do we find the definition of issue 4? Somewhere in there? somewhere else.
at 3502, issue 4, is...
Ah, yes.
Well, you've got it's the same one, isn't it?
Right, I see.
Yes.
It's rather confusingly phrased. To whom permission has been granted on this issue doesn't mean issue 4.
Yes,
apparently.
I've spent some time yesterday trying to puzzle my way through this. It has never been in dispute that if the FNR is to be taken, it is to be taken at that level, so far as the conduct of the case was concerned.
Yeah. And you say it can't come in through the back door to show that there's some inherent uncertainty about the FNR rule, but what is certain is that it applies to something, and the something has been agreed as being the...
Exactly, and you've taken me into a peroration on this particular
Or if it applies to something,
exactly.
and something is
What
agreed.
I was going to say,
Yes.
can you imagine a reference to the ECJ?
Yeah.
There would have to be an order for reference, and the order for reference would be in relation to this GLO, to this test case. And you would have to say that in this test case, it is determined as a matter of our national procedural autonomy, it has been determined that if an FNR is to be taken, it is the FNR at the water's edge level. That is determined. So
I mean, with respect, I'm concerned with a much simpler point,
Yes.
which is that if you're saying we don't have jurisdiction to consider this point because permission was refused at the Court of Appeal level to appeal to them, well then
Yes.
that saves us a lot of trouble. And we can,
yes, well, I do say that.
I mean, the questions of reference to Europe simply don't arise.
Yes, I do.
Yes, but I understand.
Well, on that point, they did arise, but they
I do on others.
still
But
arise on the point.
I just wanted to get chapter and verse for why you're saying that, and I now think we have the best chapter and verse we can get.
Yes.
Thank you.
Even though it's obscure.
It is obscure. It is obscure. There was long discussion
Yeah.
Yes.
before the Court of Appeal, in the Court of Appeal judgment.
Yeah.
And what I will say...
Yeah, I mean, I've got the point now, and so I'm content that I know what as much as I'm likely to know.
So, I'm getting...
There's another point which you say is not open to them, and that is, I think, issue 4, the evidential point. Is that embraced in this issue 4, or is it a different part of this order?
That's in 6.
It's in 6, right.
6.
Evidence of reliefs, are they? Yes, I see. It's the proof point, yes.
Yeah.
And issue 6 was refused.
Yes.
Refused, yes.
Thank you.
Ah. Okay, may I move on to Justice Leben and Haribo? That if you're against us on this, then we have to consider whether it really is just hard cheese, that we can't demonstrate what either what the actual rate of tax is, or if we have to take the foreign nominal rate at the level at which the actual profits were earned. We don't know at what level the actual profits were earned when we're dealing with these overseas conglomerates. Can we look first at Mr. Justice Henderson's findings of fact on this? This is in the core bundle appeal, Appendix 1 at tab 7. In paras 112 and 114 at MS 3633. To paragraph 112. I turn to the element of the tax credit which represents the underlying corporation tax actually paid in respect to the dividend in the source state. The main burden of the claimant's evidence on this subject, unsurprisingly, is that it would be completely unrealistic to require them to produce this information for many thousands of portfolio dividends received over a period of 18 years. Unchallenged evidence to this effect is given in the second witness statement of John McCulloch, who was then Senior Taxation Manager at Prudential, having worked in the group's taxation department since 1980.
Well, do you want us to read this? I mean, it's in your case, isn't it?
No, my lords, I'm really filleting this.
I mean, basically, it is a bit ex post facto, isn't it? In the situation in which we are now.
That is the key point. That's exactly the key point.
Yes, but I mean, the argument against you, and possibly the one which the European Court would deploy, is that you need to make better arrangements when you're managing an investment portfolio for ensuring you do get this information. That may also be a bit unrealistic, but...
No, my lord, you are following what my learned friend said, and by doing so you have fallen, I mean, into serious error. You've fallen into the trap. Exactly.
Right.
That comment made by Advocate General Cocotte, which was addressed specifically by the ECJ, remember, they refer back to, as the Advocate General said, I'll take you to the passage.
Yes, do that.
That was dealing with a situation where the legislation in force at the time did give a tax credit for overseas tax. It gave it in respect of member state shareholdings in member state companies, or in EEA.
Yes, quite.
The legislation did give a tax credit.
So you had to be prepared to operate it.
So at that time, look at the legislation, you can get a tax credit. Don't come along and say, oh, but I can't actually find out how much it was. Invest in companies that will give you the information. The legislation tells you you can get a tax credit.
Why is that different potentially from this case? If you're deemed to know what the law is, you're deemed to know that...
it's different.
It couldn't be more... It's different. I don't know what chalk is, but cheese is Kaiser. It's different than chalk and cheese. It's totally different. Here we are, where the legislation says no tax credit. It doesn't actually say that. It tells you can get a tax credit if you've got more than 10%. No tax credit is left. So how can you make arrangements to invest in companies that would give you information if it turned out 15 years later?
That's because the ECJ has changed the rules.
They've changed the rules.
So since you were actually trying to organise your taxes.
Absolutely. The ECJ's changed the rules. The national legislation did not give you a tax credit. Question 2 in Haribo, which is what the learned judge focused on and what my learned friend has taken it to, and what the state's case is replete with references to, is the case where a credit was given by the national legislation. And they're saying, das ist das Leben. If you don't get the information, that's your problem. Question 3 was dealing with the situation of investments in shares which were not resident in member states and were not resident in Liechtenstein, Norway, or Iceland, which are the EEA countries, for where there was no credit given at all. And question 3 was answered by saying the rules are precluded. No mention of the need to demonstrate what the tax credit was. I'll show you that. Question 3 is the only one that matters. Where the learned judge went wrong, and this was, I have to accept some responsibility, although I don't think it's a matter of criticism, because it takes 3.5 hours to read Haribo carefully. I've read it 4 or 5 times. I can't get it less than that time. To realise that question 4, which my learned friend adverted to yesterday, is not a question that deals with judicial remedy providing a notional credit. Question 4 deals with the National Tax Administration giving a non-legislative relief. Now, if I can just mention this very briefly. If we go back 20 years, and I think to the time my Lord Carnwath was dealing with these cases, there were things called extra statutory concessions and statements of practice. They were published concessions where the revenue, rather than change the legislation, either because it was too difficult to actually draft or that they wanted to have some discretion to make sure that it couldn't be used for avoidance purposes, they granted certain tax reliefs, known as extra statutory concessions or statements of practice. They were published and they could be relied on by and enforced by judicial review. I think it was the case of Wilkinson, if I've got the name right, where the House of Lords said this is unconstitutional. Bill of Rights, only Parliament can tax, you cannot be untaxed by concession. So we've stopped having these. That's what question 4 was dealing with. Question 4 was dealing with the practice of a national tax authority in giving credit. And they say, well, where a national tax authority gives you credit under a practice, you've got to be able to prove the credit. And what example do we have? We have the very example in that particular case. It was the Minister of Finance statement in 2008, or whatever it was, June 2008, that I can't remember what it did, but it gave some greater relief.
Yes.
It's it.
Loosen the requirements.
Exactly.
It's concerned with the requirements for providing information.
Yes, but what I'm saying is that we had in this country, until the House of Lords said it was unconstitutional, we had a whole raft of reliefs which were given by extra statutory concession. Had one of those reliefs been in an extra statutory concession for portfolio investments, and saying you can get credit relief notwithstanding section 899 or whatever the section number was, then that's what question 4 would have been dealing with. The learned judge fell into error, and I can demonstrate that that is correct quite clearly, because Advocate General Cocotte took question 4 to include not just the practice of a national tax authority, but also a decision of a court. And that was not followed by the ECJ. The ECJ was explicit. It's confined to a national tax authority setting down rules. Now, and that's where the judge went wrong. And
which judge went wrong?
Justice Henderson. That's why he thought it was hard cheese.
Yeah.
He thought, and I didn't correct him at the time.
Oh, all right, but you'll show us.
Yes, I will show you that. So can I show you, first of all, in Mr. Justice Henderson, then take you to Haribo? I think I can do it in that order. We're back in the core volume. Can I just check for one moment how my time is going? I don't want to encroach on the exciting stuff you're going to hear on. So we have Mr. Justice Henderson misunderstanding question 4. This is tab 7 of Appendix 1 at paragraph 53, which hopefully is MS 3612. But let me begin at paragraph 52. What the learned judge himself at MS 3611 describes as the crucial point. The crucial point, which in my judgment emerges from the court's discussion of question 2, is it's apparent, and as I say, question 2 was dealing with legislation that gave a credit for investments in EEA resident.
Yes.
The crucial point, which in my judgment emerges in the court's discussion of question 2, is its apparently unqualified endorsement of the principle that it's an intrinsic part of the operation of an imputation system to require the taxpayer to provide details of the foreign tax actually charged on the distributed profits even in the case of portfolio dividends. This principle, therefore, can't in itself be regarded as imposing an excessive administrative burden on taxpayers. It follows, in my view, that any difficulty or even practical impossibility for a taxpayer in providing such information can't be taken into account in determining whether an excessive administrative burden has been imposed on him. The justification for this austere doctrine is that the relevant information must be known to the company making the distribution, and any inadequacy in the provision of information to the investor is not a problem for which the member state concerned should have to answer, paragraph 98. Furthermore, the court reached this conclusion in the light of evidence before the referring tribunal that in practice it was usually impossible for investors to furnish the information required by the Austrian tax authorities, apparently even after the simplifications introduced in 2008. And then 53. It should be noted that the discussion by the ECJF question 2 was concerned only with portfolio dividends from other EU EEA states. The reason for this was that the legislation provided neither exemption nor a tax credit for dividends from third countries. In its answer to question 3, the ECJ held that this treatment infringed Article 63. Now that's key, but he just deals with it as a sort of passing sentence. He then moves on to 4, and this is where he goes wrong. While in its answer to question 4, it ruled, in effect, that the infringement could be remedied by adoption of an imputation system subject to the same conditions as applied in relation to portfolio dividends from EU or EEA states. It could be remedied, i.e. remedied by the courts. It can't. In particular, the court made it clear that the same principles relating to the allegedly excessive administrative burden that this would place on taxpayers would apply.
Why do you mean could be remedied by the courts? Surely it could be remedied by law, or perhaps by courts.
Well, he's thinking of exactly the situation we have here, where the courts are saying, well, you have to be given a credit.
I see.
He's wrong. That's not what question 4 was. And that's and as I say, I take it responsibility. I didn't point out to the learned judge why, as I say, A, Haribo is a ridiculously long case to read, but B, we knew we were winning on the main point. This was an ancillary point that would only arise if we lost on the main point about the FNR. We won on it. So I'm afraid we didn't spend as much time on that as I've had to do this time because I'm dealing with issue 4.
Where do we find question 4? Just
in Haribo itself,
yes.
Can we look at, it's in Authorities 7 again. I think I'm roughly on time. I should have another 5 or 6 minutes. It's Authorities 7 at tab 62. If we start with Advocate General Cocotte, and I'd like to
that is the Advocate General.
paragraph, yes, that's right, paragraph 15 at MS 2399. You see, by its second, paragraph 15, she deals with the second question in Haribo. She actually starts with the second question in Haribo. She moves on to the first one, which deals with double tax treaties later. So this is the bulk of her decision. So it starts there. By its second question in Haribo, the referring tribunal is seeking to ascertain whether Article 56 is infringed if domestic corporations must, as a rule, pay corporation tax on portfolio dividends from da-da-da, because it's impossible or barely possible for them to provide information on foreign corporation tax previously paid, which is required for exemption or at least a credit. And then para 57 and 58, which is at MS 2409, you'll see that the language he's using here, and these are the paragraphs which were referred to, 58, explicitly by the ECJ later on, is referring to a current situation where the investor has a choice. Such a provision doesn't require anything that's actually impossible. The necessary information is in fact available somewhere, namely from the respective companies which distributed the dividends and possibly also from the domestic investment funds through which the company shares eligible for dividends are held. If obtaining that information entails considerable cost-intensive effort, the investor must consider, someone who's actually currently investing, must consider which is more favourable to him, providing the previous foreign charged tax or relinquishing the exemption or credit. Even if such proof should ultimately not be possible because the shareholder isn't in a position, de facto or de jure, to obtain the information, this must nevertheless be attributed to the shareholder's sphere. It's in the interests of both the foreign companies and the domestic investment fund to organise the portfolio investment as attractively as possible. This includes providing the shareholder with the necessary information so that he can benefit from the possibility of preventing or mitigating economic double taxation in the state of residence. So obviously dealing with a situation where a company like Prudential, knowing it can get a credit, has to decide, am I going to invest in Krupp, which will give me the information, or in Thyssen, which won't give me the information? Or it's not readily available. That's what question 2 is dealing with. And then her conclusion at paragraph 70 on MS 2412. The answer to the second question, however, must therefore be that Article 56 EC is not infringed if domestic corporations must, as a rule, pay corporation tax on portfolio dividends from other EU EEA states because it's impossible or barely possible for them to provide the information on foreign corporation tax previously paid, which is required for exemption or at least for credit. So that's how she deals with the second question. She deals with the third question at 104, which is MS 2419, quite differently. Because this is dealing, para 104, the third question in Haribo, 2419, MS 2419. By its third question, however, the referring tribunal is seeking to ascertain whether Article 56 is infringed if provision is not made in respect to dividends from non-member state holdings for either exemption from corporation tax or crediting of corporation tax paid abroad insofar as portfolio holdings are concerned, whilst national portfolio dividends are exempt. And then 106, over the next page, it's apparent from the examination of the second question that it's justified to reserve the exemption method for national dividends and only to grant a credit for the corporation tax paid abroad in the case of foreign dividends. The examination of whether restriction of the free movement of capital exists must therefore concentrate on the fact that there's no possibility of crediting tax in the case of non-member state portfolio dividends. So she's concentrating on that. In fact, we go to para 132 at MS 2426. is conclusion. Since none of the grounds put forward can justify the fact that no provision is made for the possibility of granting a credit for foreign corporation tax previously paid in the case of non-member state portfolio dividends, there's an infringement of Article 56. The answer to the third question, however, must therefore be that Article 56 is infringed if provision is not made in respect to dividends from non-member state holdings for crediting of corporation tax paid abroad insofar as portfolio holdings are concerned, while national portfolio dividends are exempt from tax. Full stop. Punkt. No reference to you have to prove you're entitled to get a credit, the court will give you a credit. It's infringed. Why? Because there's no possibility of credit. That's exactly what we have in the UK, no possibility of credit. It's question 3 is the only question that refers. Question 4, this is very interesting because what they do is they recast the questions given by the National Court. The Learned Advocate General, she thought that question 4 was dealing, or she regarded as dealing with decisions by competent national authorities or courts. This is a para 134 on MS 2426. By questions 441 and 42 in Haribo, the referring tribunal is seeking to ascertain whether economic double taxation of non-member state portfolio dividends which infringes Article 56(1) must be prevented by the competent national authorities or courts. That's how she regarded the question. It must be prevented by national authorities or courts through the application of the exemption laid down for other dividends or whether granting a credit for the previous paid foreign corporation tax is sufficient in this regard. And then she says the answers to these questions is largely evident to the questions. And then when you go to 142, she sees how she answers that question as she understood it
We go where?
That's at 2428 or 142. The answer to questions 441 and 42 in Haribo must therefore be that the national authorities or courts may in principle eliminate systematic economic double taxation by giving their holders the possibility of being granted a credit. If, however, national law makes provision with regard to similar portfolio dividends from other EU, EEA states for a conditional exemption method or possible switchover, it would be disproportionate to allow solely to apply the imputation method. So her conclusion here was very different. So because for large holdings you can get exemption or a credit, it's disproportionate to disallow it here. I'm not going to read any further. That was not the approach taken by the ECJ to question 4. They took a totally different approach to it. So if we turn to the ECJ...
What about, can I also ask about paragraph 136?
But the refusal to apply the imputation method in the case of non-member state portfolio dividends can't therefore be justified either by the reduction in tax revenue or by the need to safeguard the balance allocation.
No, 136.
Oh, 136, I do apologise, my lord.
I'm wondering if that might not be in point.
Yes, in this context, she regards the learning of all the previous things to apply.
Yes.
As I say, that's where the ECJ differs. They don't take that approach. They deal with question 4 as if it is an existing provision, this time of a national tax authority as opposed to legislation granting a credit. And you'll see this when we come to the court. And it's the contrast between the approach of the Advocate General and the court which really highlights it. So we come to the ECJ. This is at tab 63. Question 2 is set out at para 76 on MS.
Right, where have we gone? What?
MS 2446. I hope. 76? No, 2466. I apologise. 2466.
Right.
That's question 2. If you turn to 2467, you'll see how they phrase this. By its second question, the referring tribunal thus asks, in essence, whether Article 63 includes national legislation, such as that at issue in the main proceedings, which applies the imputation method to portfolio dividends distributed by companies established in other member states or in non-member states that are party to the EEA agreement, when it's not established that the conditions for applying the tax exemption are met, whilst both true for the conditions for exemption method, that is to say comparable taxation, the amounts of foreign tax rates, the absence of personal subject-based exemptions of foreign corporation, and the data necessary for crediting a foreign corporation tax can't be provided by the shareholder or can be provided only with great difficulty. So they're dealing with national legislation that gives you a credit, but in circumstances where you can't actually demonstrate the amount of the overseas tax. If we move on to 2475, that paragraph, that's MS 2475, paragraph 104. But before that, we'll write it 2473, sorry, at para 98. And you'll see in para 98, second complete line from the bottom, they refer to the Advocate General states in para point 58 of her opinion, inadequate flow of information to the investor isn't a problem. But that was, say, in the context of where you have a choice of investment because of you know what the law is. And then if we move to 104, their conclusion on the second question, in the light of the foregoing, the answer to the second question referred to, therefore, is that Article 63 must be interpreted as not precluding legislation of a member state, under which portfolio dividends which a resident company receives from another resident company are exempt from corporation tax, while portfolio dividends which a resident company receives from a company established in another member state or in a non-member state part of the EEA agreement are subject to tax, provided, however, that the tax paid in the state in which the last mentioned company is resident is credited against the tax payable in the member state.
And getting information isn't expensive.
Exactly. Yeah. But that's in the context of national legislation. It's not precluding legislation of a member state.
It's not precluding
Legislation. It's not precluding actual legislation which tells you can get a credit.
But supposing European law is, maybe we've only discovered this through a series of decisions, but supposing that European law is that you look at the companies which have actually provided the profits, not just as the water's edge remitting company, then surely taxpayers should be taken to know that and should be taken to be able to invest in portfolios which enable them to get the information about...
If our national law gave a credit, then there might be something in your lordship's point, if I can put it with respect in that way. But the national law does not give any credit at all.
Yes, I know you say this is a matter of national law and we haven't chosen, yeah.
They're dealing with a national law that gives a credit. And it's saying, if you get a credit, what comes with a credit is a sandwich, comes information requirements. That's your choice. You want the credit, you get the information. When you come to question 3, you don't get the sandwich. There's no question. How do they deal with question 3? That's on the same page, 2475. By its third question, the referring tribunal asks whether Article 63 precludes national legislation, which for dividends from holdings in companies established in non-member states rules out both exemption from corporation tax and granting of a credit. Okay, so it rules out, you can't get a credit. And then you see 108 at page MS 2476. Since the tax treatment of dividends from companies established in states parties to the EEA agreement is covered by the first question submitted, the referring tribunal must be considered to be seeking to ascertain by its third question whether Article 63 precludes legislation such as that is issue in the main proceedings under which portfolio dividends from holdings in companies established in non-member states other than states parties to the EEA agreement are neither exempt nor subject to a regime providing for a credit for foreign tax.
And the answer must be a clear yes.
And the answer is it's precluded, and that's all they say.
Yeah.
You go to 132 at 2483.
Yeah.
132, 2483. However, the national legislation's issue in the main proceedings doesn't provide that any exemption or portfolio dividends received from a company established in a non-member state other than the state party of the EEA agreement, or any credit for the tax paid in such non-member state, is conditional upon the existence of an agreement for mutual assistance, Under paragraph 10, portfolio dividends from non-member states other than states part of the agreement are always subject to corporation tax in Austria, and the national legislation's issue doesn't provide for any tax advantage for such dividends in order to prevent their economic double taxation. And then we go to 188, which gives you the answer, para 139. By its fourth question, the referring tribunal, the answer.
Which paragraph?
It's para 188 at the foot of 2484. 138, I'm sorry, I've obscured it. 138 at the foot of 2.
Well, the answer is affirmative, isn't it?
That's right. It just simply says.
I think we ought to move on to.
It's precluded.
Question
4. And this is key. By its fourth question, which is the one you remember Mr. Justice Henderson thought applied to courts, remedying a defective legislation or non-compliant legislation. By its fourth question, the referring tribunal seeks in essence to ascertain whether Article 63 precludes a national authority from applying the imputation method in the case of portfolio dividends from companies established in a non-member state, parties to the EEA agreement, with which the Republic of Austria has not concluded a comprehensive agreement with regard to administrative methods enforcement, or in another member state, despite the fact that the method results in an allegedly excessive administrative burden for the recipient of the dividends. So, there it refers to a national authority. Para 143 amplifies this. We're not talking about the courts. Para 143 on 2486. Article 63 TFEU therefore does not preclude the practice of a national tax authority which for dividends from certain member states applies the imputation method, whilst it systematically applies the exemption method for nationally sourced dividends, provided, however, that the mechanisms in question designed to prevent or mitigate distributed profits being liable to a series of charges of tax lead to equivalent results.
And then over the page, the allegedly excessive administrative burden has already been examined.
Yes, exactly. But then look, the answer to the fourth question referred, therefore, is that Article 63 doesn't preclude the practice of a national tax authority, which for dividends, As I said, that's like an extra statutory concession, something which exists on paper where companies know that if they invest in portfolio shares, they would be entitled to a credit, but they have to take, what's it called, the grist with the, I know, sure, chaff or
I
something.
think it's the Casey and the Crider.
Exactly, exactly. We don't have a practice of a national tax authority.
Well, no, it's not. It's the opposite. It's the rough. Well, I suppose it is. Yes, it is the same sort of analogy, rough and smooth. Yeah.
So those are the points I made. Mr. Justice Henderson was not directed to question 4 in sufficient detail to appreciate the distinction that is being made by an ex post facto correction of a position by the courts, as opposed to a contemporaneous statement of a national tax authority that it will grant a credit. And therefore the doctrine, although it is austere, is not that austere. It is taking the rough with the smooth, where you have the option. We don't have that option. We are question 3, the equivalent of question 3. No credit was given. Therefore, if the court tells us that the remedy has to notionally create a credit, the principle of effectiveness applies to deal with the situation that it is actually impossible, ex post facto, to give the information that would allow the credit to be quantified.
Yeah, I suppose you could say, I mean, what Mr. Justice Henderson said was that the answer to question 4 ruled in effect that the infringement could be remedied by adoption of an imputation system, etc. And that's true if you're talking about a legislative remedy for the problem. But you're saying non-constat that you award a restitutionary compensation, if you like, on the footing that you should be expected to provide the same information.
Exactly.
Yeah.
That summarises my submissions, and unless I can assist you further, that's really, I could go on to Accor, but I don't think there's any need.
You could go on to.
There's a case called Accor,
No, well,
which was a later, but frankly, it doesn't really add that much. That was a case where the national legislation was dealing with a group, the Accor group, they own hotels, dealing with a group where obviously they've got the information within the group, because it's a group. But the national legislation didn't provide for tax, any tax credit for the overseas tax. And they said, well, you can get it, but you've got to be able to prove it. But if it turns out to be too difficult to prove, then we'll have to see what to do about it. But why should it be difficult to prove? It's a group. They know what the tax is paid by the subsidiaries. It's not a big deal. So I don't think that really matters. So unless there's anything further I can say on issue 4, apart from the fact that I hope that we don't actually have to need to grapple with it, those are my submissions on it.
Yeah, I suppose you would buttress your arguments on that, or I suppose you would say they're consistent with the general principle of effectiveness.
Exactly.
Yes.
Exactly.
Right. Then
No,
we moved.
Yes. Can I just preface my learned friend's going to say, just with one general remark looked at from sort of the EU perspective. The fascinating questions in issue 3 and 5, in particular in issue 5, carry back in the same court and all the rest of it. There are various approaches that one might consider. One is prorating, sounds equitable. Another is setting off unlawful against unlawful, unlawful ACT against unlawful D5. Sounds reasonable. Another might be, those of us remember the old days, something called sterling trust principle, that a taxpayer should be deemed to act in its best interest where you're trying to reconstruct something, where something should be charged to capital, not charged to capital,
Yes.
and the taxpayer is deemed to. There is no default setting here. They're all possible candidates. With respect, the way to approach it is say, which of these methods, or any other method, is the best equivalent to the domestic situation, the situation where you're dealing with an investment in UK shares. That is the only criterion that matters. Does prorating produce a closer equivalence than setting off unlawful against unlawful or whatever? That's the only question that matters.
So, I mean, the truth is you're not really saying there's no default setting and they're all possible. You're saying there's only one answer which is correct in principle.
In principle, the one that is correct in principle is the one which gives the closest equivalence to
Yes.
investing in
Right.
UK shares.
So that's the test we should apply. Yeah. And we've seen that in your
Yes.
case.
And unless I can assist your lordships further, those are my submissions on issues 1 and 4.
No, thank you.
Can we have a small logistical
Reshuffle,
break,
yes.
just while I get out of the way, basically? This is,
Do you literally want?
oh, no, want is the wrong word, my lord. Yes, is the answer to that question, but I'm just... We'll just swap around. Yes. That's my present particular so. Files. Yeah, you can have your files. No, yeah, pleasure.
That's fine. I'm very grateful, Lord. What I propose to do on issue 3 and 5 is adopt what we say in the written case. It's paragraphs 156 to 198. And like my learned friend, I'll deal with issue 5 first before turning to issue 3. And I'll then hand back to Mr. Beasley to address your lordships on issue 2 on the interest issue. So issue 5...
You're Mr. Bremner.
I'm Mr. Bremner. Issue 5, my lord, what we're dealing with is the correct approach to calculating the unduly levied tax in a particular context arising out of the way in which the UK system worked.
Right.
My learned friend took your lordships through the statutory provisions yesterday. I'm obviously not going to repeat that exercise. Just for your lordships' note, there is a very helpful summary in Mr. Justice Henderson's judgment in FII High Court 1, paragraphs 19 to 20, and that's Authorities Volume 5, tab 53. It's MS 1571 to 1572.
This is how the system works.
Correct, my lord.
Yes, well, you've got a good summary in your case.
And we have one there as well, which draws on that passage from Mr. Justice Henderson's judgment. It's a judgment that's been looked at on a number of occasions in later cases in these GLOs. The key point, and the only statutory provision that I need to show your lordships before I embark on issue 5, arises out of section 2391 of ICTA. And I should just remind your lordships of what that says. It's Authorities 1, Divider 8, and it's MS 4467. And this is the set-off of ACT against MCT. And what one sees is that the setting of ACT against MCT, that happens not as a result of any discretion or choice, but it happens directly as a result of the statutory scheme. That's what section 2391 does, and that's important for reasons that I'll come back to. So what we had was payments of ACT, and then those payments being set against the mainstream corporation tax liability. And functionally, what the ACT was doing was it was prepaying the MCT. Now, it's common ground, and one sees this in the judge's judgment in the Court of Appeal. This was called Decision 2. It's also, the judge himself called it Portfolio Dividends number 3. It's the January 2015 judgment, which is in tab 5 of the core volume. And paragraph 34, which is MS 3567, that records what was common ground, which is that at the time that the ACT and the MCT were paid, there was simply no distinction drawn between payments of ACT or indeed between the parts of particular payments as to whether they were lawful on the one hand or unlawful on the other. So what we're dealing with is...
One would have thought that was fairly obvious.
Yeah, indeed.
Yes.
And that's been common ground throughout. And that's why issue 5A arises. And your lordships have seen this before. It's set out on paragraph 164 in our case. It's 3478 in the core volume.
Are you going to be explaining to us what the problem was with the MCT that rendered it unlawful?
It's because there should have been a credit in respect to the foreign dividend.
Correct, my lord. The particular point I'm dealing with under issue 5 is how one allocates the portions, the unlawful and lawful portions of the ACT as between MCT when the MCT itself has unlawful and lawful portions. I mean, I will come back to deal with the
I mean, that's because... and it gets complicated at this point. That's because you can't trace ACT, which is subsequently utilised, to any particular part of the MCT against which it is utilised.
That's right, my lord. And it's also important to
if it can be utilised in a simple statutory situation against the next, against corporation tax for the accounting period in which it's paid, things ought to be rather simple, oughtn't they? But I suppose you can have all sorts of other factors affecting the amount of corporation tax you pay, which would reduce it below the ACT, and you would then have to start carrying the ACT backwards or forwards.
Well, my lord, it's even more than that. We get to issue 5, even leaving to one side points about carry forward, carry back, all the rest of it. The fundamental reason why we get to issue 5 is because when one looks at the corporation tax against which the ACT is being set, it's not just D5 tax, it's not just the tax that we're arguing about in this litigation, it's corporation tax on any profits of the company. So you could have perfectly lawful charges that have nothing to do with this litigation at all.
So it could be said, ACT, you could have no corporation tax which is attributable, could you to the same source as the ACT is charged on, or
yes. So if I can just dip in,
yes.
If I just dip into the example that's in 168 in the case 3480, what we're hypothesising there is just UK interest income.
Well, sorry, where have you gone?
So I'm in our case. Yes. It's page 3480 of the core volume.
Yeah.
And the base example that we give.
Yes.
So the profits in question upon which the corporation tax is being charged, that's the UK interest income. Now, as a matter of statute, the way in which one gets there, it's 239 sub 6, because that tells you, if we still have Authorities Volume 1, which tells you this is MS 4468.
Yeah.
That's the profits of a company charged a corporation tax. That's the amount of profits for that period on which corporation tax falls finally to be borne. And if one goes back to MS 4465, this is section 238 sub 4, and the gist of that is it's all the profits. So it's not just profits that result from receiving dividends. It could be all sorts of sources of income, and those other sources of income may have been lawfully charged. So I hope that answers your Lordship's question.
Well, you were showing us the example at 3480.
Yes, and that is an example where in the example at 3480, what we're dealing with, the 50 of corporation tax, that's been generated by the interest income of 200. And that's got nothing to do with cross-border dividends or anything of that sort.
Right.
So that's the scenario that we're having to deal with. We identify the competing methods in para 165 of our case, that's 3478 of the memory stick. And it's a competition between, on the one hand, what we say is the principled approach, and I'll make this good, of unlawful ACT being regarded first as utilised against the unlawful MCT. Contrast the revenues approach, which is to say take a pro rata approach throughout. Now, can I develop my submission as to why we say that our method is correct in principle? In my submission, the starting point is that what one needs to do is to work out how the ACT, so that's the prepayments of the MCT liability, how would those prepayments of tax have been utilised under a lawful system? So we've got to start with the UK system, and we've got to look at how it needs to be adapted. And we say that our method does exactly that. So 165.1, that's exactly what we're doing. We remove the unlawful prepayments and the corresponding unlawful payments of tax. And then what we do is we look at how the remaining payments on account were dealt with by the UK system. So what you're doing is you take out the unlawful elements and then operate the system on the basis of the lawfully paid tax. And that's what we seek to demonstrate in the example, which we set out over a number of pages at paragraph 168 in our case. And just to be clear, but I hope we've touched on this in my answer to my Lord Manser's question, what we're dealing with is a mixed fund of lawful and unlawful ACT, and what we're trying to do is work out how the unlawful ACT was utilised. We only get on to the remedy issue about how to characterise the situation where the lawful ACT is used against an unlawful MCT charged later. That's issue 3. So at the moment we're starting with a focus on the unlawful tax. Now, I only really need to show you, Lordships, one part of the example that the gist, and we've set it out in writing, is we start with the domestic situation. That's 3480. 3481, we assume that there's foreign income where full double taxation relief should have applied. And then what I need to focus on, because of the fact that full double taxation relief should have applied, all the additional charges on the foreign income are overcharges, and I'm going to come back to...
Basically, the UK corporation tax shouldn't have been charged on the foreign dividend income. So
yes,
basically, at the end of the day, you paid, on that analysis, £25 too much.
At 34...
Part of which you would say was paid by way of ACT.
3481, that's exactly
Doesn't
right.
Doesn't matter how you divide it up, though, and the ACT is, in fact...
Yeah, and that's the comparison at 3482. That shows the tax that was overcharged. I'm going to come back to my learned friend's objection. It's the only objection he makes, which is to say, well, hang on, when the ACT was set against the MCT, you didn't actually pay it. I'm going to deal with that in a moment. But what one has, and one sees this...
Yeah, sorry, you'll come back to it. Henry.
You know, I absolutely will deal with it. It's the only objection that's being taken against me on this issue, so I need to deal with it. 3482, what this has, and this follows from the observation that my Lord Mance made, all of the additional ACT and all of the additional MCT was ex hypothesi overcharged. And they're the numbers in red. So you've got the red of 18.75 of ACT and 25 of MCT. Both of those were unlawful. Now,
But the 18.75 is only unlawful for a period, and it's part of the 25, effectively, isn't it?
yes, that's right. So 1875 was paid too early.
Yeah.
And then, well, and then
Then the whole of the
how much of it's part of the 25 depends on who you're with on issue 5.
Yes, I see.
But because what actually happened at the time is that you had the charge of 75, that's back to 3481, and then 5625 of ACT was used to meet that, and part of that was lawful and part of that was unlawful. The point I'm making at the moment is I'm focusing on the unlawful charges, which are the figures in red. So it's 1875 of unlawful ACT, and it's 25 of unlawful MCT. Now, the critical point in my submission is, suppose, for the sake of argument, and this is my learned friend's case, that the unlawful tax was a nullity. That was what your lordships were addressed on yesterday. That's my learned friend's approach. If it's a nullity, my learned friend says, well, 239 didn't operate in relation to that ACT. There never was a valid D5 liability to set against it. And I've got submissions to make about that under issue 3. But if you work on the basis that those charges didn't happen, they were invalid, and my friend says they didn't happen, if you take the unlawful ACT of 1875 and the unlawful MCT, that's the 25, you take those out of the tax return, because my friend says they're a nullity, so let's work with that hypothesis. Where that gets me to is that the amounts of ACT and MCT that were set out on the return, they were overstated by mistake by the amounts in red.
Right.
Too much was set out, and then the provisions operated. But as we saw, when you look at 2391, so when we look at section 2391 of the statute, which I showed you lordships earlier, what the statute does is it applies the ACT that's on the return against any profits, so not just the D5. So if you simply excise the unlawful tax charges and you then allow the UK provisions to operate according to their terms, what 2391 will tell you is that the remaining ACT, so that's the lawful ACT, that's the black figure, 3750, that simply gets applied to the remaining MCT, that's the lawful MCT, again, the black figure of 50 at MS 3482. So it is as simple as removing the illegal charges and allowing the UK system to operate according to its terms. That's my
The effect is that you have been wrongly required to disburse ACT, a certain amount, and then a balance, making the total disbursed up to 25 by way of alleged MCT. But those two disbursements, the ACT and the MCT, are void, effectively. Well, they're not lawfully due. They're actual disbursements, but they're not lawfully due, so you say you recover them.
No, well, one has to be careful about focusing on the notion of disbursement. We know what was actually paid when.
Well, you can have a disbursement by a de facto set-off.
Oh, well, that's a submission that I'm going to come on to under issue 3. I'm trying at the moment to keep issue 5 and issue 3 separate, which I hope will be more helpful to your lordships. I don't want to get ahead of myself.
Maybe we're dealing with a sort of prior point, which is, and I mean, go through what's happened to the 1875 again on your submission.
So, Prudential's approach is really very simple. You ask, what is the difference between the lawful system and the unlawful system? And you remove the unlawful tax charges and you allow the UK provisions to operate according to their terms. And what that does, in my example at 3482, is I would be removing the red 1875 of ACT, because everyone agrees that was unduly levied. That's common ground, or unduly charged, if my friend seems to be levied with connotations of payment, but leave that on one side. MCT 25 was overcharged, and we simply say remove those two elements and allow Section 239 to operate. When you do that, you see our method on 3483, you are simply associating the 1875 of unlawful ACT with the unlawful corporation tax, so that's removed. And then 239 simply operates on the lawful elements. So when it comes to computing the claim, you proceed on the basis that 3750 of ACT lawfully was paid, and that lawful ACT was then set against a lawful liability of 50 of MCT, and then you get your cash balancing payment. That's what we set out, subject to rounding in the...
Plus the time value of the fact you paid some of it earlier.
Exactly. And as the judge found at paragraph 36 in decision 2, and for your lordship's note, it's MS 3568 in tab 5 in the core bundle, our approach precisely reflects the credit for foreign tax required by EU law. That was what the judge found. So we say, for the reasons I've given, that our approach is the right approach as a matter of principle. Now, both in his speaking note, and this is paragraph 28, it's the same point in little a and in little b, and also in his oral submissions yesterday, what my learned friend did in relation to the example that I've just been showing you lordships was not to challenge the maths of the calculation. Rather, what he did was to take a conceptual point. The nub of his response was an argument that it was only the MCT that was paid in cash that was actually paid. And so what my learned friend was submitting is, well, you should ignore, for the purposes of calculating the restitution, ACT that was utilised against unlawful MCT, because the revenue say, well, that's got nothing to do with the restitutionary claim. That's the point I'll come on to under issue 3. But that conceptual objection in my submission doesn't work. It forgets the revenue's own position that the unlawful charges should be regarded as a nullity, and it forgets the operation of section 2391. Because if, as my learned friend says, the unlawful charges simply don't exist, the only place you get to is that section 2391 applies according to its terms to the amounts that were lawfully charged. And so what one sees is that there is an inconsistency at the heart of the revenue's prorating approach. What it does is it assumes that the unlawful ACT existed, but that the unlawful D5 tax didn't. So it's not being consistent. The other point that my learned friend's response highlights is the interrelated nature of these computational issues, because for my learned friend's response to have validity in relation to issue 5, he first of all needs to get home on issue 3. And as we'll see when we get to issue 3, my submission will be that he's simply wrong about issue 3.
Am I being oversimplistic if one looks at 3481, one looks at the ACT, which is actually paid, one knows that that includes an element of overpayment of ACT in respect to the foreign dividend income. That element of overpayment must be calculated, I think, at £18.75. That's 25% of £75, which is the £100 foreign dividend income less tax, is that right?
Yeah.
So you paid, undoubtedly, £18.75 at the ACT stage, and then at the balancing stage, your case is that part of, actually £6.25 to make it up to £25 total, is attributable to the failure to give proper imputation credit against the foreign dividend income.
My Lord, that's right, but that's mainly to do with issue 3.
That's right.
So yes, but in terms of the cash movement, in the example, 1875 of cash is paid, and then when I get to issue 3, my submission is that in this example, I've made a payment of 25. My clients have made a payment of 25, 1875 by way of the statutory set-off provision in 2391, and 625 in a further payment of cash.
Yes, I mean, I at the moment I'm having difficulty separating issues 3 and 5, or seeing.
Well, it's a problem that my learned friend has as well, because the nub of his submission depends on his answer to issue 3 being wrong.
Right.
But one does need to take it in stages, because what we're doing at the moment is we're working out of this undifferentiated fund of ACT
Yes.
and this undifferentiated fund of MCT.
Right.
Some of each fund is lawful, some of it is unlawful. Nobody knew at the time, and as a part of the calculation exercise, we were engaged in working out what parts of the lawful ACT should be treated as used against.
But your basic proposition is that the unlawful, nothing should be used against the lawful. You should just extract the unlawful element.
Yes.
And that's what you require restitution in respect of.
Correct.
Insofar as the unlawful element has led to overpayment at any stage.
Right. I mean, the basic principle underlying my submission is we have to calculate what the excess tax is. That's the amount that was overcharged. The amount that was overcharged is caused as a result of the respects in which the UK system did not comply with the requirements of EU law. So we are consistently with that when it comes to our calculation. We are asking how would matters have operated. This has nothing to do with choices that Prudential would have made. It's simply how would the system have operated had it operated lawfully.
Yeah.
So that's what we're doing. Prorating is a fundamentally different exercise. It's asking a different question. It's saying in a world where we don't know which parts of the fund were actually used, can we have a proxy in order to come to a view about which parts of lawful and unlawful ACT were used in what way? But my response to that is that's not the right question to ask. We're not asking that factual question. We know what happened in terms of how much ACT was paid, what was set off, what extra MCT was paid. What we're needing to do is to ask, how would the UK system have operated if the overcharges hadn't been there?
Yeah.
So that's the submission on issue 5.
I mean, really, pro-rating makes sense if you're talking about valid payments and valid debts, and or valid payment and valid debts in the plural. You don't know where the payment has gone.
And that's not what we're dealing with here. And that's where, because I'm going to show Your Lordship the Court of Appeal's reasoning, and that's where I say that the Court of Appeal fell into error. And because they saw this as essentially a factual question, what had happened in the past. And so they stopped, but that was not the right way to look at the question, because the prorating approach, what you end up doing is muddling up and intermingling parts of the lawful charge and parts of the unlawful charge. And it was that aspect of prorating, and this is what the judge noted in Portfolio Dividends 3, it's paragraph 36, MS 3568, that the result of that was that there were anomalies.
Sorry, what was the reference?
Sorry, it's paragraph 36, and it's what the Court of Appeal called Decision 2, and it's MS 3568.
Yeah.
And that was a finding the judge made by reference to a slightly different example that I developed before him, which my friend accepted to be correct, as the judge records in paragraph 36. I set out the same example before the Court of Appeal. The Court of Appeal wasn't impressed by it, and what I'd like to do now, with Your Lordship's permission, is show you the Court of Appeal's reasoning and just make good my submission as to why that's wrong. But I don't, given that the example's been common ground from the beginning, that the judge refers to in paragraph 36, I'm not going to take up time with it just now. The Court of Appeal, the reasoning starts at paragraph 119, so we're in the core volume, tab 2, and it starts actually at paragraph 113, is the beginning of the Court of Appeal's discussion of what it calls the ACT sub-issues. And what one sees in brief summary, the three main reasons that the Court of Appeal gives are at paragraphs 119 to 121. And what they say is, first of all, they thought the relevant question was a factual question about how big was the unjust enrichment. They relied, that's paragraph 119, both at 119 and 120, they thought it was important that at the time everybody thought the tax was due, no one was to blame. And then 121, they said they thought that pro rata was a fair method for striking a balance and provided an objective standard. They were the three main reasons. There's one ancillary point that I'll come back to. Those three main reasons, in my submission, simply don't meet the case, either that I advanced to the Court of Appeal or the case that I'm advancing to your lordships, because what the court failed to appreciate is that what needed to be done was to identify how the ACT and the MCT would have been paid and utilised under a lawful system. It's that fundamental point that the Court of Appeal, in my submission, simply missed. And the way you do that, as I've said, is by stripping out the unlawful charges and letting the UK provisions take their course. Just for completeness, the Court of Appeal did also make a fourth point, and this is paragraph 126, MS 3540. And I should just explain this because it's not explained in any detail in 126. In my respectful submission, paragraph 126 is actually a non-point, but the Court of Appeal sought to link what they called the clear and principled, they say it is in line 1, approach for bringing credits for foreign tax into account with their ruling on prorating. Now, they don't really explain that, but just so your lordships know what the Court of Appeal had in mind, what they were pointing back to was the conclusion that they had reached in paragraph 105, which is MS 3536. Now, 105 is dealing with issue 10, among others, in the Court of Appeal, which has not been pursued by the Revenue before your lordships. And this was the question of how the additional tax credit should be linked with onward payments of dividends so as to work out when it was that ACT had been overcharged. And what one sees in paragraph 105 is the Court of Appeal rejected the revenues linking method of trying to work out how much EU money had been paid up and said, no, all you do is you take the additional tax credit and you feed it into the UK system. They say in 105 as a modified form of FII, effectively. So that's what they were deciding in paragraph 105. But that reasoning in paragraph 105, that had nothing at all to do with the utilisation issue that's now issue 5A before your lordships and was issue 21 in the Court of Appeal. What the Court of Appeal was doing in paragraph 105 was looking at how do you use, or when in time do you use the section 231 credit. So that was about working out what tax is lawful and what tax is unlawful. That didn't have anything at all to do with prorating. It was an entirely different point. So 126 in the Court of Appeal's judgment, in my respectful submission, simply underlines the Court of Appeal's misunderstanding of the issue that it was dealing with. Last point on issue 5A, and this is just for completeness. My learned friend said yesterday, it's page 118, lines 9 to 16 in the transcript, that there'd been no appeal in FII against Mr. Justice Henderson's ruling on utilisation. Your lordships will recall that the chronology is that in FII High Court 2, Mr. Justice Henderson endorsed a pro rata approach. He was persuaded in this litigation, by me as it happens, to take a different view, and that was the paragraphs in Decision 2 that I was referring to earlier. In FII, there was an appeal on that issue, but because the Court of Appeal had decided what was then issue 21 adversely to Prudential, that automatically determined the appeal on that point. Oh.
Yes, you are drifting off into...
Oh, I'm sorry, I've lived this too much, I'm afraid, my Lord.
If any of that matters,
it may.
Just give me some dates. In FII number 2, say Mr. Justice Henderson endorsed a pro rata approach.
Yes, he did.
What date was that?
Oh, so the judgment there was December
2012.
2014.
14.
If I remember rightly.
Yes, you're quite right, 2014, right? And then you say in the present case, he went...
And then in
this case...
So in this case, he gave judgment, as it happens, in January 2015, and he didn't follow that earlier reasoning. He was persuaded, as I say, by me, as it happens, to take a different view.
Well, in between the two? In the space of a month?
So 3 years.
Oh, wait a minute, 14, and when was the January?
Well, that was simply how it played out, my Lord. I don't want to take up time.
No, anyway, I've got the picture.
The only point I'm making is that there was an appeal. Yes. The appeal, however, was determined by what the the appeal in FII was determined by what the Court of Appeal said in this case. That was the only point I was trying to make, and I don't want to take up time.
No.
Justice Henderson's considered view supports you.
Yes, it does. And that's decision 2, and it's particularly paragraphs 34 to 36.
Yeah.
That's all I wanted to say on issue 5A. Issue 5B deals with repayment of ACT. Now, we set this out, it's paragraph 173 in our case. MS 3485. Now, just on the background, if I can just summarise what we're dealing with. In any given quarter, ACT was charged, and my friend made this point yesterday, on the difference between the franked payments and the franked investment income. You paid ACT on the balance. Now, the problem that we're dealing with in this case, as we'll see, is that the foreign income here should have been given credits, but wasn't. That's the ruling that the Court of Appeal makes in paragraph 105. Yes, a modified form of FII. And so what has to be done is that foreign income has to be added on to the domestic franked investment income that Prudential had at the time. And so to work out the excess tax, you have to work out the total FII, both the modified foreign form and the domestic form. You have to take that total FII and you deduct that from the franked payments. That gives you the excess amount on which the ACT's been paid. And that's the right basis for computing the excess tax. Now, the reason that issue 5B arises is because in one very particular circumstance, this is where domestic FII was carried back to an earlier accounting period. The revenue want a different approach to be taken. Now, for your Lordship's note that the legal position, because the provisions are complicated and nothing actually turns on their complexities, is actually quite a simple answer to issue 5B. But the legal position is summarised in paragraph 129 in the Court of Appeal's judgment. And that is quoting paragraphs 41 and 42 of the judge's judgment in this case. And the short point is this, that there were circumstances where, at the time, domestic FII was carried back to an earlier accounting period. And I emphasise domestic FII. It was generated by dividends paid by a UK resident company. That FII has got nothing at all to do with this claim in terms of overcharged tax. So we say that applying the normal approach, you work out how much, I use credits as shorthand just to cover the domestic FII plus the modified foreign FII. How much in the way of credits should Prudential have had, and work out what tax Prudential should have paid under a lawful system. And that's what our approach to issue 5B does, and we show that in the example at 181. I'm not going to ask you to look at it just now. What the revenues say, however, is that when the FII that had been generated at the time by the domestic income, when that was carried back, what should happen is that that domestic FII should be applied pro rata to lawful liabilities and unlawful liabilities. Now, my learned friend in his speaking note, he makes one key point, and this is paragraphs 29 to 31 in that speaking note. It's page,
You mean his
page
case?
14.
What speaking note?
Oh, I'm very sorry. I've called it the speaking. It's the document entitled Appellant's Response on Cross Appeals.
Oh, yes, right. Oh,
Which was filed on Friday, and,
Yes.
and I'm afraid I don't have
Yes.
any electronic references
right.
for it.
So,
But
Which paragraphs?
it's 29 to 31. The critical point, and this really was the only answer that my learned friend has given, either in writing or orally on issue 5B, is that the ECJ, he says, was not mandating a form of credit for EU FII. That's paragraph 31, line 3. Now, learned friend, he's made no attempt to defend the reasoning of the Court of Appeal on this issue. I will look at the Court of Appeal later, but that's the nub of my learned friend's case. So in paragraphs 29 to 31, what my learned friend is doing is quarrelling with the point that what we need to do is identify and give effect to additional tax credits. Call it FII, call it something else. I don't mind so much, but that's the point that he's taking issue with. And if that would be a convenient moment for your lordships, I'll show you after the short adjournment why that point is not even open to my
The
learned
judge
friend.
got right on this point.
In terms of what the judge ruled on this point, yes, I say the judge got it right for the reasons that he gave.
We've got his paragraph.
I can give those to your lordship.
41 and 42.
It is 41 and 42, your lordship's quite right. I'm very grateful.
right. We look forward to your further submissions at 2 o'clock.